morning to one and all present. Our Dean Professor Dr. K.S. Sir, Director Sir, Professor Vijayakumar Sir, and all faculty members and all members who are present online. We have with us today Professor Dr. Vijayakumar. We welcome you, sir. As we reach the end of our APP session, sir is going to enlighten us. Sir has been the former Vice Chancellor at National Law India University, Bhopal. He has also been the former Vice Chancellor at Dr. Ambedkar Law University, Chennai. He has held the UNHCR Chair on Refugee Law and is at the board of several national law schools, steering various policy issues. With various papers to his credit, he has been awarded the Amity Academic Excellence Award and the Best Vice Chancellor's Award by the Indian Red Cross Society, and has been instrumental in changing the course of legal education in India. We welcome you, sir, and we are very happy to have you amongst us here.
How many of you are teachers of constitutional law? Only 3, 4. Right. Good morning to everyone. Good morning, Prof. I chose this topic basically for 2 purposes. One is some of you must be trying to do your PhD, right? And maybe looking for some good topic or reasonably a good research, right? The second one is to raise certain issues so that you can continue to agitate this point as you proceed in your teaching, in your research, in your interactions in the classroom, or whatever the case. Therefore, the title that I selected was Constitution versus Canon. And my apologies right in the beginning because I will ridicule the Supreme Court left, right. A sufficient amount of respect, but they are not going to change, right? Unless and otherwise, our research and publication will tell them in Harvard Law School, the moment the journal comes out, the 9 judges of the Supreme Court will go through to find out that whether the judgment is being questioned, ridiculed, commented upon, and if the reasoning given in that article is better than what they have done, they wait for the opportunity to change their view in the next statement. But in India, the judges are not willing to read anything. Even if you write, there is no guarantee, and therefore we don't write. So there is a mutual appreciation society, right? So I start with this criticism. That as for the Constitution, I think everybody must have studied constitutional law. For that, we will not get anything. Right? And everybody must have done a master's degree without constitutional law, the new challenges, where there is no child taxi. Right? There is also another way that you are all equipped with constitutional law. You are teaching some other course. I would like to start off with 3 important blunders associated with the Indian Constitution. Right? The Indian Constitution, when I say the text of the Indian Constitution, right? I brought this book, I gave some other book between. We call this as text of the Constitution, but you will see at the bottom somebody has written Bare Act. Right? It is not an act passed by the Parliament, and it cannot be called as an act. So this is the first indication of how we treat the foundational course called Constitutional Law. Right? So therefore, with the text of the Constitution and the way that we have performed our obligations in the last 70 years, right? There are 3 important blunders that we cover. I want you to carefully listen to this, and then I go to conventions and how we have proceeded on. The first blunder is that we wrote the lengthiest constitution in the world. Right? We must ask the question whether it is a blunder for itself. Right? 395 articles, 8 schedules, no, there are 12 schedules, right? 105 amendments, right? And when students and the teachers selection takes place, they say they are experts in constitution. I ask them, how many amendments are being made? To be very frank with you, if I interview 100 people, not even one gives the right answer. That is the state of affairs in looking at the constitution. Right? So, when this constitution is it a crime? The answer is not a blunder at all. Because if you take the American Constitution, the first written constitution, very brief, 7 articles, 27 amendments included 35 years, right? But that is only a federal constitution. All the 50 states have their own independent constitutions. So if you store all of them and place that federal constitution, it will be taller than this podium. Whereas the Indian constitution is not that big, which is common for both center as well as other states put together. So I would like to modify the statement, telling you, writing a lengthy constitution by itself is not a standalone blunder. But when you relate it to the second blunder, this also becomes a blunder. You got the point. First, I started off by saying that we wrote the lengthiest constitution. Now I am modifying the statement a little and give you some one or two facts here and there. By itself is not a standalone blunder, but if it is to be read with the second one, it is a new blunder. Right? One country overtook us in the 70s. They wrote much lengthier constitution than the Indian constitution. Can anyone handle which country overtook? They wrote much lengthier constitution than India's.
Russia.
Huh?
Russia.
Huh? Yeah, please don't, because if it is wrong, it's okay, it's fun. I want you to raise questions. Don't listen to me. You raise questions and you have to respond. Yeah, any other country, one or two? Russia, I said no. Don't ask Google Baba. That's what the students do. I'll give you a clue. That country is not in the political map of the world today.
USSR.
USSR. That's why the Russia, USSR, not USSR. Any other? Huh? Yugoslavia.
Yugoslavia.
Yeah, Yugoslavia. Yeah, somebody must have used Google. Okay. Right? Yugoslavia wrote a lengthier constitution. Where is it today? And the smallest, briefest, first written constitution of 7 articles is the most powerful nation in the world. So it is not the length and breadth of the constitution that is important, but it goes with the people, the leaders, the political leaders who occupy the position, strengthen the nation over a period of time, and that is what is important. Right? So therefore, the first blunder is writing a linear constitution, not a standalone blunder. But the second blunder, if you know what it is, then you know first is also a blunder. Then you may ask the question, what is the second blunder? The second blunder, Himalayan blunder that I have committed is that after writing the latest constitution, we are not ready. Right? Very simple to remember. Now you understand the first one is also a blunder. Right? If I give you a text of the American Constitution and the text of the Indian Constitution to you, one day I will give you the Indian Constitution, ask you to read as much as possible before you reach Majestic in a bus or sitting in a car. You look at this, it's a big constitution, there to read this, where to start, by the time you reach Majestic. But if I give the American Constitution, by the time you reach Majestic, you would have read at least once. Right? So therefore, why is it so? I have 2 issues I would like to point out here. Now it is nice to hear a talk of it, but we are not ready. I need to do this. Right? Why? The preamble starts with a beautiful phrase. What is it? We have adopted even to ourselves this constitution. Have you read it? Right? The general excuse is when it was adopted, I was not even born. So I did not read it. Right? One excuse is valid. The other one, statistically, if you take all the lawyers in this country, third grade, fourth grade lawyers also, right? They have not attended any class, but still they get gold medal of the university, right? With whatever malpractices it's possible, right? All the lawyers put together, practicing, non-practicing lawyers, all the law students put together, all the judges of the courts, tribunals, Supreme Court, everyone put together, the total population of this will not be even 1% of the total Indian population. And if in that 1%, if we have not read this constitution, how do you think that the constitution is able to deliver this? Okay. Right? The Chief Justice of India is on record. He said that one may not know everything. But we also teach the students ignorance of law is no excuse. Right? But the judges can escape by writing any judgment they want. For them, ignorance is not an excuse. Unless it is pointed out that you have committed a crime. So now, I have given you two reasons as to why we don't read. And the third thing, which I have not mentioned, I said only two. Third one is, as teachers of constitutional law or international law or any other law, one among the essential tools you should carry to the classroom is the text of the conventions, the constitution, or the bad act of Indian Penal Code, Evidence Act, Non-Consumer Protection Act, any act that you want to use. I think that gives you is an equipment, is a tool, right? So when you read the tools in the classroom, when you carry it, the students will also start carrying it. When you just go without anything, then possibly students also come without the paper and the pen. So I jovially say university and institutions have become the case where teachers go there without interest to teach, students go there without interest to learn. Both of them enjoy the time. I think education cannot go like this. Right? The second one, blender. After seeing the first blender, second one is also a blender. Because of the second one, first one is also a blender. Third one is directly related to the topic I am going to discuss. Right? What is that? Conventions. After writing the latest constitution in the world, right? After writing the latest constitution in the world, we have borrowed conventions practiced in other countries, particularly the countries like United Kingdom, where there is no constitution. That's number one. Following those conventions is nothing wrong with it. But when there is a written text of the constitution, can you blindly follow those conventions or the customs? Is a test. And that is a place where we have committed the blunder, the Himalayan blunder, through interpretation by the courts, and courts are squarely responsible for this. Right? Political leaders are squarely responsible from 1950 to 1973 or 74. After that, it is the blame entirely shifts to the court. And the political leaders, they have gone from bad to worse, so we can't change it. Right? So therefore, the constitutional conventions of other countries, when you try to read them and implement them through the court's orders, as against the written provisions of Indian Constitution, I think we continue to commit the third blunder. Third blunder is incomplete. Right? We continue to commit. I'll just give you one example. The Privy Council judgments, I don't know how many of you are looked into. Right? Please let me go back. Out of curiosity, just log on to the Privy Council, read some of the judgments. On any judgment, subject of your interest, not interested in the subject matter, still Download one, it's all available free of cost, right? 8 pages, 10 pages, right? Very quickly, whatever they have to say, they have to say it in that 6 to 10 pages, maximum 12 pages, right? 5 pages page, right? In 1980, the Privy Council decided the case. Canada is a colony of, was a colony of, it continues to be a colony because the chief executive is appointed by the Crown Government in Canada. Right? The Lieutenant General or whatever they call is appointed by the Crown in India. That's why I said still it is continues to be a colony. Though they have an independent constitution. The title of the case goes like this. You can also download and read. Attorney General of Ontario, Attorney General of Ontario versus Attorney General of Canada. Very easy to remember. Don't have to remember. Ontario is a province, one of the 10 provinces in Canada, versus Attorney General of Canada. So the person between federal and state attorneys. Decided by the Privy Council in 1980. 1980. It's more than 5 years old now. And one sentence I would like to tell you. Privy Council judges, they are all judges of English origin. They have referred to the Canadian Constitution and said, if the text, please carefully listen to this, if the text of the Constitution is explicit, if the text of the Constitution is explicit, it is final as to what it permits and what it prohibits. Right? Once again, I am repeating this sentence. In the text of the Constitution, that is the Canadian Constitution, and the judges where there is no written Constitution, and those who are interpreting the Constitution of Canada, saying, if the text of the Constitution is explicit, it is final as to what it permits and what it prohibits. You don't have to come all the way to Privy Council, right? Similarly, in 1964, there was another judgment of the Privy Council, Adet Benro. You don't have to note it down because I will agree to it. Again, the Privy Council judgment, 10-page judgment. It was a judgment, it was a case which went from the Supreme Court of Nigeria to the Privy Council on appeal. Indian Supreme Court also had final appeal going to the Privy Council earlier. Till the government of India, after coming to court, they passed the legislation to remove them. In Australia, even today, the High Court judgment can be sent to the Privy Council on appeal. People don't do, but it is possible. Right? So, Nigerian Supreme Court judgment, they went to the Privy Council, and very beautifully those 5 judges mentioned, please don't look at the constitutional conventions of India. No one can fathom what it is. It is an element which has run over 400 years of our politics. That is from 1600, right? The two stewards coming into picture, then that is not many laws developed thereafter. 400 years of practice of conventions, customary laws. Therefore, don't look at the English conventions to interpret the written provisions of your constitution. You have written, you have adopted it. You try to implement it. Right? And therefore, they send the issue back to the Nigerian Supreme Court. Now, what do you understand by this? Even the judges of the Privy Council are very clearly telling, go back to your own constitution. And only the Indian Supreme Court, we are saying, no, we want to go back to. Why? Because that is the only way to dilute the internal provisions of it. And that's what happened. Right? Once again, to cap up what I said, the 3 Himalayan members, right? First one is they wrote the English Constitution. They told you it's not a standalone. But second one, we have not really scientifically proved, right? What it means leadership and how we don't use the things. We don't read that, right? We have not read. How many of you have read the Indian Constitution at least once? Not read we are going to the last schedule. I have done. Many students in the law school have done that. Right? Then only understand and tell the Supreme Court, you are not relying upon the Constitution, but you are relying upon the British Constitution. If somebody says you got freedom, I would rather say, I'm sorry, you don't. Right? Have you looked at it? No, I'm just trying to prove something. Now you can use your mobile phone and you can take the text of the Indian Constitution. And fill to Article 395, last article. Right, Article 395. I will read it for your benefit. You got it? Right? The Indian Independence Act 1947 and the Government of India Act 1925, together with all enactments amending or supplementing the Indian Act, but not including the abolition of Privy Council Jurisdiction Act 1949, are hereby repealed. So when the Constitution was adopted, still we have the jurisdiction of the Privy Council. The Constitution itself has not been removed, but subsequently the Parliament will adopt. Now, if you actually look at it, the Indian Independence Act 1947, right, has been repealed by Article 395. Is it possible for the repeal of the Indian Independence Act? If yes, what will be the consequence? You got the point. I don't know what intention they wrote. Right? Do we have the jurisdiction to repeal? Who can repeal? If the Indian Independence Act was enacted by the Parliament of India or the Constituent Assembly, then you have every authority to repeal it. Right? That was made by the British Parliament. How can you repeal it? Assuming that you have the authority to repeal it, what it means that we don't have the independence because the Indian Independence Act has been repealed. Right? And therefore, I think the judges have read 395 carefully. And they still feel that we don't have independence, go back to London for everything. Right? Whether the interpretation of the Constitution or the laws. I'll give you examples. I'm not simply looking around. I'll guide you through some of the provisions. I'll tell you, I'll ask you a few questions, I'll take your answers, and then tell you where we have gone wrong. So the third one is using the Constitutional Conventions of England, even against the written provisions of the Indian Constitution. Right? So this is the foundation on which I would like to build. Right? So I will not go back to explain what is meant by the Constitution. That will be very pedantic, very complicated. I assume that all of you know what the Constitution is. Right? It is not only the text of the Constitution, all the enactments made by the center and the states, because our interactions do take place based on that. The judicial decisions and unwritten codes of conduct. Rule of law. The Supreme Court keeps on saying our country is governed by rule of law. I don't know. Right? So the rule of law is not written down anywhere. But the Supreme Court very authoritatively keeps on saying that our country is governed by rule of law. Where is rule of law? It's not written down. Constitutionalism, where the arbitrary exercise of power is being checked. Right? There is a written down, nowhere is written down. So therefore, all these things, including the constitutional conventions, form part of the domestic constitution. It's not only the text, right? It includes all these things, including the judicial decisions. Why? Because of Article 141, right? Article 141 very clearly says the laws. What is the language? Huh? Declare. The Supreme Court cannot make law. The law declared by the Supreme Court shall be binding on all courts. Right? So it is this binding nature. Even if it is wrong, it is binding. So there is one uniform way of interpreting throughout the time. Right? Now there is a catch. Is every judgment a law laid down under Article 141? The answer is no. I was quite amazed in the National Judicial Academy. The retired judge of the Supreme Court was also with me. And when I was telling about Article 141, law is to be declared, not every judgment is not declared. Every judgment possibly will resolve a dispute between two contesting parties. Need not necessarily be a law declared. Immediately jumped at it, no, every judgment is law declared. I looked at the director, he said, I moved on. Right? So the phrase used is not, this is the reason why if you don't read, right, then you presume, then you say, okay. But what is declaration? Declaration comes into picture when there are two plausible interpretations possible on the same, right? And then the court takes one particular interpretation and says this is the law laid down. Right? If at all in the future we come for interpretation, we will keep this interpretation as final. Law is to be declared. Law is to be declared. Otherwise it is not binding. Right? So therefore, constitutional conventions occupy an important position in the making or breaking of the constitution. In India, it has only contributed to the data in breaking the constitution because we have gone to the English constitution to copy the conventions there and then try to interpret, try to implement it here in India. Then it goes on. I told you first 15 years or 14 years, I'm sorry, 2 years. There was a tug of war between the president and the prime minister. Right? It was made obvious. Right? The foundation laying ceremony of the Indian Law Institute. The president inaugurated it. He laid the foundation and inaugurated in his address. He said, Rajendra Prasad, right? That you have to do a little bit of research. Indian Law Institute, you have to undertake some research on the powers of the president. Evening, the Prime Minister entered address. He said, if you do the research, you will see only a foundation show. Nothing else. Right? It is only reflective of the tug of war between the Prime Minister's office, two powerful leaders. Right? And then Rajendra Prasad contested for the second time against the wishes of Nehru. No, you should not sit a bad president. It is very simple. The Constitution does not prescribe, even today, does not prescribe any limit. Right? In the US, there was no limitation. So therefore, Theodore Roosevelt, if I remember right, not the two Roosevelts, right? Theodore Roosevelt contested the election for the 4th time. Immediately they realized, it becomes a vested interest. So they amended the Constitution with a purpose, with an objective. And they did not say only one term. They said 2 terms or 10 years, whichever is higher. 2 terms is 8 years or 10 years, whichever is higher. Which means if the Vice President dies, the President dies, The vice president will act as president for the residuary period. If that period is more than 2 years, you can be elected one more time. If it is less than 2 years, see, magnanimity, you can be the president for 10 years. They amended the constitution. Here there was no such limitation, so I will contest. He contested. And the tug of war became even more obvious when the Hindu code, I don't know, family law teachers will know it, the tussle between Rajendra Prasad and the Prime Minister. Ultimately, they truncated it and passed different enactments. He was a strong president. He wanted to attend the proceedings of the parliament to see what the governments are doing in the service. I think literally, isn't it? Every day we don't go to, this, what is this, crime stories. Best stories are there in the legislature and the parliament. Right? And he wanted to go and see. Prime Minister said, please don't do that. The president pointed out, please see the definition of parliament. Parliament includes the president and the two houses. Therefore, I have every right to come. Every year I have to come and address the joint sitting of both houses. Why do you say that I should not come? Then if you say, please, I cannot explain. You don't come. But we will make you to listen to the proceedings. You sit in a chamber. So there was the radio, not telecasting or broadcasting. The proceedings into his chamber, which he could sit and listen. So when he wanted to make a point, it was based on the constitution. I am also part of the parliament. I have every right to come. But he pleaded and said, please don't check it too. Because once he is present, dignity, decorum, decency, and today even that is gone. When the governor says, the decency and decorum is completely gone. Today they say, governor, I. Right? President, I, challenge, I think we are nowhere near those conditions. Right? So, Hindu code bill, all these tussles very clearly bring out the tussle. And therefore, both of them agree to refer the matter to what we call it as the Attorney General. Who appointed the Attorney General? The President is supposed to appoint, the President has appointed. Who selected him? The Prime Minister. So, Nehru was smart enough to say, we will refer the matter to Attorney General. And the President also, I only appointed, so let me also take it chance. Right? Settle what? First Attorney General. And he wrote that President has no powers. He has always to abide by the decision taken by the Prime Minister and the Council of Ministers. That is the address that he had given. Right? In spite of it, this tussle took place, continued to take place, and his second term was also over. First term was 1952, second term was 1957. So 1962, he said he is going to contest the election again. You have to understand, because this is politics, we are talking about politics, not the constitution. But it has a direct implication on the working of the constitution. Nehru had to approach various leaders to convince and request, except falling at the feet of, Rajendra Prasad. He influenced every other leader to request him, please don't let us. 10 years and finally, he withdrew his interest in contesting. If he had contested, even against the Congress party's nomination, he would have won. You got the point? But he wasn't. So therefore, the tussle between the President and the Prime Minister, in accordance with the written words of the Constitution, was writ large. The first mistake committed by the Attorney General was to rely upon the British Constitutional Conventions and saying, no, in India, the Crown has to follow, if the Crown, even if the Kachik is stopped by the Crown, he has to take the permission from the Prime Minister to pick it up. Right? I don't think the Indian Constitution has reduced to such an extent. Right? And I don't know whether somebody has to fight to become the president, if that is the case. And maybe anytime we go, for a function, one ambulance in the front, one ambulance at the back, the security, everything, you enjoy it for 5 years time. After that, nobody will come to you. Right? So whether these are all the issues that we need to look at it, and once a wrong direction, once the first step is taken in the wrong direction, any amount of progress in that direction, still we are in the wrong direction. I hope you understand what I'm saying. The same post in those days, right? Where 4 or 5 roads meet at the center, there will be a signpost saying that this road will go to Bangalore, this road will go to Oslo, this road will go to Delhi, or some other place. Made out of wood. As still, I'm talking about I'm a native of Oslo. There used to be 2 lakes. I have learned my swimming in those lakes only. Right? We used to come out and see this signpost. We go and test it. Right? 8th standard students we enjoyed it. Then I don't think I can do it. Right? We twist it. And which means if anybody comes, not this type of party, once in a while, some bus, once in a while, few cars will come. If by looking at that, if they get into Bangalore, with the Bangalore road, they will be just going in the opposite direction. Right? And at least the milestones are there to warn them. If they don't see, blindfoldedly keep on moving 20 miles, 30 miles, you are going in the wrong direction, you will never come to point 0 again. And that was the mistake committed by the Attorney General in the Constitution. Right? Another one, Rajal was last, but still he continued to fight. Right? Then thereafterwards, the choice of the office of the presidency was and continues to be the realm of the political process. Right? If as a single largest party in the country, if the Congress party declares that so is a candidate, we will show for it. Generally, if you say a donkey, the donkey will also do. Right? That needs to be level to which the office of the executive has been delegated by the political bosses from 1950 to 1974. 1974, a new twist came. I come to that later. Therefore, what is this convention? I need to explain. Can anyone have come across the term convention? Constitutional convention. You will also see convention halls everywhere. They are not marriage halls or meeting halls. Right? Convention basically is a meeting. Right? And that is how the American Constitution, if you have to amend the Constitution, 2/3 majority in both houses, and then 3/4 ratification by a convention or independently, they can all come together, and that's a convention, or ratify independently. Till the 34th state ratifies it, it cannot become an amendment. Right? That is the term convention is used in the Constitution itself. But here, when we are using constitutional conventions, it uses the term usages, practices, right, followed from time immemorial. That applies to England. Right? All those practices that you see, Cabal, how we did Cabal come into the picture. Right? It is a 5 important advices to the crown. Right? That became the cabinet. Cabal became the cabinet. Right? So they had a rich tradition. 100 years, 200 years have gone. Then members of parliament election. Representation of people came much later. Cabal came first. Right? So therefore, we have to look at all these aspects. You see, constitutional conventions in England means those usages, practices relating to the government, right? Relating to the 2 houses of parliament, relating to the relationship between the crown and the parliament, relating to the cabinet and the parliament, relating to the cabinet and the crown. These are all. There also the crown appoints a prime minister. It's only a formality. The leader of the majority automatically will close his right sign and So these are all governed by unwritten volumes of constitutional and they are good people. And that is why the conventions play an important role and continue to play an important role even today. You must have seen Sunak, who has been elected as the Prime Minister, right? How different process within the party, how many people contest, one after the other withdrawing, sophisticated way of living. And here, if you give AK-47 to each of the leaders, I think that is the best way to reduce the political domination in this country. Right? So this way of relying upon constitutional convention, and they said, it is which keeps the constitution intact. You don't have a written constitution, but it keeps all those principles together for ages, and they have not deviated. They have not deviated. Even today, they have not deviated. Right? Maybe I think 3 or 4 times they tend to deviate, but they have come back to the convention again. For example, once a speaker is always a speaker. That's what the convention says. Once a speaker is always a speaker. What does it mean? If I get elected as a speaker, as a Labour Party member, I resign from the Labour Party. So that I become value neutral in dealing with the members of all political parties in the House. If I continue to be a member, there is always a bias at the back. I may not display that openly, but there is a bias at the back of my mind, and my decisions will be colored with that, character mind. You got the point? And that is why, what is that, in Maharashtra, or say is that, Shivsena. And all these members, went out, 3/4 of them, right? 2/3 of them. The other speaker who was representing this, they said, I am going to disqualify you. But when this was recognized and they found the government, the other speaker comes and says, no, you are all very good. I disqualify the rest of them. You got the point, right? Even in the written and schedule formula that we have adopted, we have bias. Why? The speaker in England, this is the convention. Once he becomes a speaker, subsequent election, nobody will contest against him. He will automatically be elected. Now, even I think 3 occasions or 4 occasions in the 20th century they violated. But still they realized that importance and they have come back. Unless otherwise the member says, enough is enough. As a speaker, I have seen all the time. I don't want to be a member again to this house. Finished. On his own, if he goes out, it's okay. Now, do we have a law? Do we have a constitution to say this? No. It's a lot of practices which are placed higher than the written provisions of the constitution. They are placed higher. Right? And that is the place where the conventions play a vitally important role. Right? Whether it has any role at all in the written constitution is a question. I gave you the Privy Council interpretation, wonderful interpretation. If the text is explicit, it's final as to what it permits and what it prohibits. Right? Is it possible to have constitutional conventions in written constitution? The answer is yes. The answer is yes. Why? No constitution, even now in 2023, is complete in every sense. Is complete in every sense. There are always gaps. You cannot think of everything and put everything in the text. Even if you put everything in the text, it is a changing society. Right? New circumstances come up. And you have to respond to those new circumstances. Right? In the entire constitution, we have not written that the leader of the majority party will be called as by the president to become the prime minister. No, it is written. On the contrary, it says the president shall appoint the prime minister. And on his advice, appoint other ministers. Right? And it also says the president has the power to remove the minister, not with the concurrence of the prime minister. The council of ministers old office, right? In Article 75 is very clearly given. The consequence of the house. If somebody is corrupt, somebody has committed a crime, murder. I think we have a union minister, right? From one of those Jharkhand, I think, if I remember right. Right? And ultimately was not convicted and continued to go off. Right? There are many of them. We come out with again, as we last, the person who has so much of money in his banks, accounts, so on and so forth. And now he is a minister. Can you remove him? Will the governor have any authority to do that? Is there an answer? If you search for the constitutional text, you will not. So the text is one, and the conventions are the oil to the machine. The engines to run smoothly, the engine is political engine. To run smoothly, the conventions serve the purpose of an algorithm model. They are not totally independent, but they are part of it. They are independent because it's a lubricant and you have a machine. And without this lubricant, the machine cannot function. And therefore, every constitution in the world today is not complete in any sense or in every sense. And therefore, they have to rely upon these conventions. And this is the place I would like to take 2 minutes off, right, from the focus and go back to a fundamental question. What is the difference between a custom and a convention? Any response from your side? Because you are not questioning me, I am going to question you. At least to keep you awake. What are the differences, if any, between a valid custom and a valid convention? Now, what are the ingredients of both? In our common law method or legal method, we have talked to our individual students also, right? Custom has 4 important essentials. What are they?
Long usage.
It has to be followed from time immemorial. That is the language I was taught, not long time. The custom or usage must have been followed from time immemorial. When it started, we cannot know. Right, such a practice. We didn't know anything. Right, we did not know anything. It started somewhere below. It should have been followed from time immemorial, which means at least one generation should know that it originated even before. Then it must be
certain.
Continuous.
and continuous. Right? I follow the custom for 10 years, disobey the custom, again follow it, again discontinue, that's not a valid custom. That's not a valid custom. So we are not questioning the validity, but we are looking at the ingredients. Right? It must have been followed from time immemorial and it must be continuous. The third one, universal. No, even otherwise you will not follow it. Universal is not one of those ingredients, at least as I have read in the students. It must be based on public policy and public opinion. That is acceptance. Right? You say the same thing, right? I'm also saying the same thing, wide acceptance. I'm not saying wide acceptance. Wide acceptance, even killing each other is widely accepted. That's not a valid system. Right? Public opinion, right? And everyone accepts it. And finally, such a custom shall not go against any law, whether the law is made earlier or after. The custom may be followed from time immemorial or centuries together. But today, if the parliament makes a law, to put an end to that, finished. It cannot be valid custom at all. And that is why today, sati is not being practiced. If anybody practices it, anybody who promotes, who is present in the vicinity, all of them can be prosecuted and punished. So a tradition which was good for centuries has come to an end because the law did not want that. That's how, reason dictates. Right? Custom has no reason, it has a belief. But here, law, reason has to dictate. And the reason dictates, and therefore, we have to do it. I told you, can you give a proof of whatever we discussed in the Constitution? Is there anything which says that there is also custom is also valid now?
Article 13.
13. Article 13, what?
Law.
13, which clause? Clause 3. Clause 3, which subsection, which subclass? You should give all those things. Huh? Clause 2, what does it say?
Law includes custom usage.
All of them, and finally, custom or usage having the force of law within the territory of India, not somewhere in India. Right? Custom or usage having the force of law within the territory of India, the last one. So it cannot go against it. But what I am going to say now and prove now is that we have customs or constitutional conventions which are against the law, against the written constitutional provisions. Often not against the written constitutional provisions. Right? If this is custom, what is a constitutional convention? And why did I choose this as constitution versus convention? They have to go together. But I use this because to prove, to at least arouse some interest in you, to look up for those constitutional conventions which are against the written provisions of the Indian Constitution. Right? That is a purpose. Otherwise, both of them have to go together. They have to be hand in hand. I told you one is an engine, the other one is a lubricant. Right? So they cannot one versus the other. No. The title is misleading. Title is not misleading because I am going to tell you how the courts have interpreted. Right? Saying that lubricant is more important than the engine. If you just carry the petrol in your hand, you cannot run at 100 kilometers speed. Right? So that is the reason why you should ask this question as to why I call this term as constitution versus convention. I cannot call this constitutional conventions. Right? Okay. What is a constitutional convention in the Indian context, not in English context? English context, I told you, 600 years or 500 years of development. Right? The Magna Carta will take maybe 900 years of development. They are all customs without a constitution, but they are called as constitutional conventions. There is a beautiful book. I hope that must be available to you in any of these, legal databases. Jeffrey Marshall. The title of the book itself is Constitutional Conventions. It is worth reading. Right? If you don't get it, there is also one more book, one chapter, last but one chapter, right? Of a book written by Justice P.B. Mukherjee. Justice P.B. Mukherjee. Critical problems of the Indian Constitution. See the irony. He delivered the first seminar lecture to the Bombay University in the 64. And the Bombay University published it. The cost of the book is 50 rupees. So when I was teaching in the law school Bangalore, I think I must have purchased more than 100 copies given to all these lectures that I came across. Please read these ones. Right? In that there is a chapter, Constitutional Conventions. Please read that. There are any number of books, English authors, who have also written about customs and conventions. And any jurisprudence will also give you something. Right? The conventions are those practices not followed by the civilians. It has nothing to do with civil. Custom has to do with the civilians. Right? Constitutional convention in the Indian context has everything to do with the political process, political actors. The Constitution and all the political actors, everyone, including MLA, whoever is, the Prime Minister, Chief Ministers, everyone put together. And what is the relationship? The federal constitution, central and state. We used to look for a convention in England for center-state relations. Right? It is a unitary state. Right? So therefore, the constitution conventions can develop in a written constitution within the four walls of the written text of the constitution. It cannot be above that. No convention can claim itself to be superior to the text of the constitution. If there is something that is missing, you have to reason out and then develop a convention, and then if the convention is good, you follow it. Now we say we follow English convention, right? What happened to the speaker? Once the speaker is always a speaker. Is there any place that we have followed this? That he has been a speaker to speaker, next time we got message direction. In fact, the other speakers have raised questions. I don't want to listen. Somebody, ask this question. You are a speaker. You are supposed to hold a neutral position. Why didn't you listen from your political party? The speaker asked the question. If I listen from the political party, next time I cannot come to the house. If you guarantee that, see the question. If you guarantee that, I will listen. If you guarantee that, which means we have half-hearted development. Wherever it is convenient, we refer to the English convention. We are not willing to follow that. And if you follow it, there's nothing wrong. No. So one side custom is there. Constitutional convention, the first condition, it must have been followed from time immemorial. It's not applicable. It's not applicable. The second principle is applicable. It must be continuous. Once you establish a convention, it must be continuous. It must be based on public opinion. Of course, certainly. It cannot go against the law. Certainly. And that is the only way that we bring the conventions within the four corners of the written text of the law. Right? And the last thing, the first one is negated. All other three we are applicable. We are making them applicable to conventions. The first one we are rejected. And contrary to that is the convention. Conventions can be created within jiffy. Convention can be created within jiffy. If you don't have a leader of the largest political party, majority political party, leader of coalition, is there anything written here? Even the largest party, there is nothing written. Right? Can I appoint two deputy prime ministers? There's two. The Supreme Court, the Honorable Supreme Court. The right said there is nothing wrong in it. Chaudhary Charan Singh, right? Two deputy prime ministers possible, and that is why Nepal saw all these things. 7 deputy prime ministers. In the constitution, they are written down. Right down, it's all right. Some jokers are worse jokers. Right? Nepal has 7 prime ministers, small country. There is a need for 7 deputy prime ministers, but that is a term of law. Right? So therefore, we don't have to look at the British conventions. You can create anything. If you say that a deputy prime minister is also, because prime minister is also a minister, deputy prime minister is also a prime minister, then why not we call all the cabinet ministers as deputy prime ministers? Like Shivkumar, we can satisfy everyone. Right? I'm not talking politics. I'm only constitutional law is not devoid of politics. Somebody very beautifully defined constitution as a twilight zone between politics and law. Right? You separate one, the other one cannot exist. Right? So therefore, you can create a constitutional convention beautifully. Once you create it, it must be continuous. When I say it must be continuous, who follows it? Who is there to enforce it? There is no one to enforce it. It is auto-regulated. If the convention is based on the right reason, it is auto-regulated. Just because Congress party said the convention, Janata party cannot say I will not follow. Because the Congress party must also apply the basic reason and then create a convention. Any other political party will follow. Right? So therefore, all the constitutional conventions can be created in the absence of the written provisions. And when I say this, the other side also is true. you cannot create a convention as against a written provision of the Constitution. Is it something French I am speaking about or Latin? It is very simple, fundamental principle. If you try to create a convention as against the written provision of the Indian Constitution, right? The Constitution cannot do anything. Convention will take over, right? Only the control will get done, right? And that is what is happening to this Constitution, right? Is it clear? In fact, I have got some papers. I thought of creating all these definitions. Unless and always I give all these things to you, I cannot read out. It doesn't serve any purpose, right? That's why I'm just going reading something here and there, right? And then, therefore, the sanction or approval for the Constitutional Convention is that institutions which are operating respect them, promote them consciously, and they treat it on par with the written provisions of the Constitution. You got the point? If at some point of time there is some inconvenience between written provisions and the convention that we have created, there is nothing wrong in violating it. Make a law, make an amendment to the Constitution, you can incorporate it. And the convention goes on. The moment you make a law, the convention goes on. Right? And if you read Article 254, what a beautiful language it is. Whether the law is made prior to or after the state law is being made, it shall be declared void. So therefore, a constitutional amendment could be made to remove a convention. But making a convention, what is required the reason, the right reason. Not for a moment to say something and then regret why you have done. Right? Okay. So this continued the tug of war between. So after the demise of Nehru, and this way really did not infringe upon the rights of other institutions to a great extent. Right? Of course, they also respected each other. Inaugurating the president or inaugurating the parliament every year. Every bill has to be signed by him. All these things were done. But at the back of their mind, they had some sort of tussle. And that is how the office of the president and simultaneously the office of the governor did not take off in a meaningful manner as provided in the Constitution. I'll just give you one question. Can the president impose president's rule in Manipur and dissolve the house tomorrow or today? It's a simple and straight because something is happening. I can't tell that with respect to Karnataka, then it becomes politics. Right? And that also is possible. Government, right? Without testing it, and then dissolve everything. First, assembly resolution. Right? It was done under the leadership of not the Prime Minister, the President of the then President of the Congress Party. And somebody asked the question, my father is a saint. He has come into politics. I am not a saint. Right? The majority government in Kerala was dissolved. Now, that's why I am asking this question, can the Legislative Assembly in Manipur be dissolved by the order of the president?
The government needs to give it.
There is no, please read that. You are right. That's only one part. Or otherwise, Article 356 says, on a report or otherwise. Otherwise, also, if you want a report, you will call the governor. No. By the time you sign, the report will come. What's your answer? Anybody online? It's not a complicated question at all. It's very simple and straightforward. Yes? Why there is so much of hesitancy? Right or wrong, we have to participate.
Can you take the question? Can you take the question? Dissolve.
This always legislative assembly, right? That is the answer introduced Supreme Court will be. As a student of law, as a citizen of this country, as one among the we, the preamble, please go to Article 356. Where is the question of dissolution? Dissolution is not here. The dissolution term is not at all used in 356. What it says is, where the state government cannot be carried on in accordance with the provisions of this constitution, to take over the government, you administer, right, for some time, and it is not perennial, it is not 1 year, 2 years that you have to continue. Hand it over to the government and all. And that is the duty imposed on the central government under Article 355, is to ensure, duty to ensure that not only the defense, every government is carried on in accordance with the provisions of this constitution. So dissolution is not there. Today, I am not finding fault with you because our mind is now influenced with what we are seeing. More than 130 governments are being dissolved, legislatures are being dissolved so far. So what is wrong? Can that convention override the provisions of the constitution? That is the issue, right? And the Supreme Court is not able to stop it. When Gomez's government was dissolved, the legislature was dissolved. The government dismissed and the legislature dissolved. Right? Dismissed, government is dismissed, legislature is dissolved. And he went to the court. It happened sometime around 88, 89. The court, Supreme Court took its own civil legal time and said, no, you cannot dissolve the assembly. Right? However, in this case, we cannot revive this because the election has already taken place. Government has come into the picture. What is the use? When you cannot give relief to the individual who is knocking on the doors for justice, within the time frame, the Supreme Court cannot be supreme. For me, the judgment of movement is nothing but the written on the piece of paper. You don't give anything. Right? So therefore, the convention of dissolving the legislative assembly, which is not present in the language of Article 356, and that has never been read with Article 355. If you have, please read that, read 4-5 lines, right? If you read that, then you will understand what I am trying to say. Right? The title of the article goes like this: duty of the Union to protect states against external aggression and internal disturbance. Right? It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and that is the important part of it, and to ensure that the government of every state is carried on in accordance with the provisions of this constitution. That gives a legitimacy for the president to use Article 56. Because the government is not carried on in accordance with the provisions of the constitution. Right? So therefore, the conventions can be created in a jiffy, but it cannot be created against written provisions of the constitution. Right? I will just ask a question. I will not respond to it. Right? Article 124. Article 124 speaks about consultation with the Chief Justice of India. Right? Now, can by any circus, any while consultation can become concurrence. We have to change Oxford Dictionary. I don't think the Supreme Court has the authority to do it. And number two, in the Constituent Assembly, it was discussed. They wanted to use concurrence. Dr. Ambedkar very clearly said, please don't do that. The Chief Justice of India is also a human being. All the babies in the common mind will have the big house under it. Some sort of bias, caste, religion, language, everything. So, you should not make it the final authority, therefore consultation to consult. And such are the judges. You can consult 2 judges, you can consult 5 judges, you can consult all the 34 sitting judges if you want. And the Chief Justice of the State High Court or any such judge of the High Court, number any such of the judges. It is the discretion left to the President and his office to consult. Now they say, no, consultation means concurrence of the Chief Justice and 2 senior most judges who are clearly eligible. Right? Is it a law declared? The answer is it is law misdeclared. Got the point? So the Constitution still continues to have this language consultation by any wild imagination, however superior the court will be. Right? Cannot do it. So this is one such issue which I just want to flag because we don't write. Right? I'll give you the implications. That is what I want to keep your eyes and mind open. Can the Supreme Court supervise the High Courts? All the subordinate courts, the supervisory jurisdiction is specifically provided under the Constitution. Right? To the High Courts. Can the Supreme Court supervise the High Courts? The answer is no. The answer is no. But by this collegium, they are not only supervising, they are interfering in the affairs of every High Court. You know what is the implication? To that extent, justice is at stake. Justice is at stake. I was addressing a colloquium in 2005, and Justice Gopal Gaurav was the Chief Justice in Odisha. It is about appointment and removal of judges. And Ishwar Bhatt was chairing my session, and I was the only presenter. I had 45 minutes at my disposal. There were more than 20 sitting judges and retired judges who were present. My opening remark was that even after 55 years of the commencement of the Constitution, we are not able to find a judge, right, who can stand above the Constitution and decide the laws according to the Constitution. We are not been successful in identifying a single judge. Caste, religion, minority status, right? We forget about all other criteria. I have interacted with many Chief Justices of India. I tell one story, they give me 2 stories. I had the privilege of teaching with Justice Vijayakumar for 9 years till his death. Right? And many stories I have heard. Right? At one point of time, there was a Christian vacancy in the Supreme Court. And there were 2 judges, Chief Justices, one from Karnataka, one from Rajasthan. And then there is the language used by this is in India. One was a corrupt judge, the other was an inefficient judge. Is it that you have to choose between these 2? What happens to the concept of justice? Right, you are supposed to render justice. You think that you have to, a Christian judge or a Muslim judge or a Hindu judge will deliver better judge than the constitutional yardsticks? I think that is a case where we have let down all these principles. And today, without reading the Constitution, we are saying many things what we think as right. And that is why I am saying the first blunder is still a valid blunder. Second blunder is much more valid because we don't read it. Right? So therefore, up to 1974, right, the tug of war between not only the President and the Prime Minister, slowly the tug of war between the government in power and the tax to North, right? 24th Amendment, the Parliament said they can do anything they want, and similarly the Supreme Court endorsed. Now I want you to actually listen to this. When I am teaching a judgment, particularly constitutional bench judgments, you must be doubly cautious and you must mention everything. For example, 1950, the Constitution came into force. We amended the Constitution Right? Autonomy was made in 51 itself. Can't we make a law? We can certainly make a law. If we make a law, the answer is no. I'm talking about the removal of judges of the Supreme Court and High Court. You are supposed to make a law based on two grounds given in the Constitution. You cannot add a third ground. Right? Misbehavior or incapacity. They did not make a law. But after the judgment was delivered in IC Kolkata, 1967, 1968, the Judges Inquiry Act was passed. What was the intention? The intention was to remove the Chief Justice from office. Who was the Chief Justice then? One of the resource persons for this DB, Subbarao. Right? Chief Justice Subbarao. So 1968 they made Judges Inquiry Act. 1969 they made the rules. See the speed in which they have done. And an intelligent judge like Subbarao saw the writing on the wall and he started interacting with opposition political parties. On their confidence, resigned as the Chief Justice of India to contest the presidential election. He knew 100% he will be defeated. But still he wanted an honorable exit from the court. Not what the parliamentarians assembled together and vote whatever the Prime Minister says. Right? And therefore, he contested the election, lost the election, peacefully came back to Andhra Pradesh and settled. Otherwise, take it from me, he would have become the first judge to be removed from office. Can a judge be impeached under the Indian Constitution? Can a judge, because many judges of the Supreme Court also use this language. The judge can only be removed, can never be impeached. The consequence may be one of the same, right? But the process of will be different. Only one person can be impeached. That is the President of India. The language is very crystal clear. We don't read it. The moment the second house passes the resolution, the President stands impeached. There is no further action. In all other cases, the houses will pass a resolution, request the President to remove so and so from the office. And the President has to do it. Then only it can be done. Right? So if you are not able to read and understand, the people can say anything they want. And we are not talking about the Constitution, some of the conventions which are against the Constitution. Now, 1971, we had the war in Pakistan. War lasted for about 14 days. But the emergency lasted for 5 years. Emergency lasted for 5 years, 71 to 75. 75, it was substituted with a new ground. Right? Internal disturbance. 7 years. And during this period of 7 years, please open up your mind and see. The Constitution got amended 18 times. From the 24th Amendment in 1971 to 46th Amendment, 42nd Amendment in 1976. And 42nd Amendment is lengthier than the American Constitution. Right? It's not a small amendment. They try to amend everything, but the next two amendments that the Janata Party came to power, they only redrafted everything and put it back to the original level to the extent possible. Right? Now, do you think that these are all valid provisions, valid operations? Then comes, so therefore what I'm trying to say is, you have to understand the political climate in which the Supreme Court decides. In 1973, the much celebrated case of the Gandhi, which is being dissected, and being killed overall by all the researchers, basis for the Constitution, right? I put it in one single language. In my school days, I read a story. 5 blind and elephant. Right? 5 blind people went and lives to different parts of the elephant and explained, oh, elephant looks like this. Does it make any explanation on the level? The same thing, 13.9, talking about the basic structure. And one principle I just tell you, please you have to apply your mind. Critical thinking comes out of it. Not simply mugging up and going and saying whatever you have to say in class. First, the tag end of that judgment, right? Mountains of tables were used, rivers of things were used to write the religious judgment. That's what they say, right? It's of no use. For the society, it's of no use. Because the first thing they say is, therefore, we overrule Government's judgment. Indira Gandhi was the only leader who understood that statement. Not our academics, not the lawyers, not the judges. Because he knew that it is overruled to expand the powers of the court. You got the point? To expand the powers of the court. Yes, Golabnath only said it should not offend the fundamental rights. Now, based on the basic structure, it opens up the entire constitution. They can look into anything and say federalism is a basic structure. Golabnath did not say that. Golabnath very sincerely wanted to protect the fundamental rights, nothing else. Right? She knew that immediately she wanted a larger bench to be constituted. A larger bench was constituted, consisting of 50 judges. They had one or two meetings, and finally it was done. I will give you a story shared to me by Justice Krishna himself on this. So, in that context, 71 till 77, all the judgments barring ADM Jabalpur, right, needs to be reviewed. ADM Jabalpur, for having written the judgment, one judge lost his opportunity, right? HR Kunal. Right? So, the emergency, the political climate also is essential for us to understand why a particular law matter, why a particular judgment has come, and then we start analyzing it. Whether it is based on good reason or not, and you have to tell, because 99.9% of the population are totally illiterate about the constitution. Totally illiterate about it. They don't know nothing. Just what going and standing before the text of the constitution. Namaste Karami Krishna Yoga. You do that and then go and violate everything. So therefore, this is one opportunity, right? How much time I have? I can go on for some more time.
Yes, sir.
Right? So you will suffer. Okay. I would like you to read the next important stage. The judgment delivered by the Supreme Court consisting of 7 judges. Because they have to overrule the 5-judge bench. That's why 7-judge bench was constituted. Samshir versus State of Punjab. 1974 Supreme Court. Samshir versus State of Punjab. Because what was involved in that? It is about the removal of a district judge in Punjab. Right? And the governor had the power in those days, and that's what the earlier judgment said. Now they have to overrule it. So the Justice Krishna here was among those judges. The Chief Justice of India, the then Chief Justice of India, for himself and 4 others, they wrote the judgment. I will come to the judgment in India. Justice Krishna here wrote a separate judgment but concurrent judgment. Separate but concurrent judgment for himself and Justice Vijay. See, when you go to the class, we don't know what we will mention the names of these judges. Now, when you read the judgments for the lawyers, for the judges, you will understand the political climate, their obedience to a particular type of, philosophy. All these things will play a major role. Now, I read the judgment in the All India Reporter, right? Time and again, and I used to give this as an essential reading for all the students. In those days, reading medium. The 44 pages will be there. And another 40 pages of Prabhu Mukherjee text also will be there, which makes you think. I'm not saying whatever Mukherjee said was right, but at least it opens your mind. It gives you the avenue to challenge and question. Right? So, in the high judge, judgment written by the Chief Justice for self and more arrest, he did not use Article 141 at all. I want you to carefully listen to this and verify it. And tell me I am wrong at the level of right? Because I told you Article 141, it says you have to declare the law. Right? You have to declare the law. Justice Krishna here, for self and Justice Bhagavathi wrote a judgment. At the fag end of the judgment, he writes, therefore, we declare this to be the law. Therefore, we declare this to be the law. My question is, basically, can one judge writing judgment for others can declare the law for all the 7 judges? When the 5 judges judgment written by the Chief Justice does not declare it. Right? So therefore, that declaration is a useless declaration in accordance to Article 140 of the Constitution, because it's not a binding law in my opinion. I will be wrong. I want you to challenge this and question me so that I can give you much more details. Right? Now, this judgment is the one which has rewritten the Indian Constitution. Rewritten the Indian Constitution thoroughly. Whether the Supreme Court is competent to do that, my answer is no. But can they do it? They have done it. That's the proof. 7 judgments and it is binding. Even today, they are quoting the same judgment over and over again. I'll tell you what it contains. All the 7 judges were unanimous in one thing, that the president and the governor, in this case it is the removal of the district judges in Punjab. I don't know why they have taken the governor and the president, right? Shall act only on the advice of the Council of Ministers. Right? And for justifying this, Krishna has said, we have adopted parliamentary form of government. Have we adopted parliamentary form of government? But we read the judgment. We go and tell the class, note down, take down. If somebody writes we have not adopted, then you give a decimal mark. Right? Till date, I have been asking this question: when did we adopt? Where did we adopt? Why did we adopt? No answer. Some stupid fellow wrote somewhere, some lawyer argued the case in the court. We have adopted parliamentary. CY says this. CY is not the constitution maker. If you do the constitution parliament, right? Good writer, fine. Just because he keep on quoting the same thing, we have adopted parliamentary form of government. We have not adopted. Second paragraph. From parliamentary form of government, we have ministerial form of government. Ladies and gentlemen, please read what is meant by parliamentary form of government. Burgess, a noted political scientist, right? Very beautifully defined the parliamentary form of government and the presidential form of government, where the executive power holder is elected and removed by the parliament, we call that as parliamentary government. Today, the British Parliament can make a law repealing the Act of Settlement 1701. The crown goes to Thames directly. Right? The institution will guide. That is the power of the parliament. Whether the Indian parliament has such a power to visualize the president of the government, the parliament is also a creature of the constitution. Therefore, it cannot take a different position, a higher position. Right? And look, from parliamentary form, they did not understand what parliamentary form of government. The pity is, they also quote all books, whichever is convenient to them. They don't see the judgments, other books. To come to a proper conclusion, which is rational. Okay, I am likely to come like this, for this many reasons. Second paragraph, from parliamentary, we have come to ministerial form of government. After 2-3 paragraphs, India has cabinet form of government. After another 3-4 paragraphs, we have prime ministerial form of government. I'm not joking. Please don't mistake me. I'm not joking at all. That is why I give you the judgment to open your eyes and read it. In the same judgment, we have from parliamentary form of government, which we have not adopted so far, to ministerial form of government, cabinet form of government, then prime ministerial form of government. So the prime minister and the council of ministers will advise the president and the governor shall act only on the advice given by the council of ministers, except few circumstances. There are few exceptions. And they gave 2 exceptions. Stupid fellows, they don't understand. Right? I'm not joking. Stupid fellows, I'm very confident. The 2 exceptions that are given is also constitutional. The election of a member of parliament or state legislature can be disqualified by the president or the governor. He cannot do it on his own. He has to refer the matter to the election commission. And receiving the opinion from the election commission, he will only write the report, disqualify the person. Right? 102, 103. Similarly, state legislature. Is it an exception that we are talking about? It is a constitutional provision. The age of the judge, the chief justice will decide. It's a constitutional provision. Few exceptions. If few exceptions can be what is constitutional, why not constitution itself become an exception? Please read Article 72. Just for the sake of the title. What does it say? Power to pardon. Who has the power to pardon? President and the governor is another article. Governor has the power. Now to pardon, do you have to act according to the advice given by the council of ministers? Please read Hebrew Sudhakar versus Andhra Pradesh, state of Andhra Pradesh. The argument of both the advocate of Andhra Pradesh and finally the Attorney General of India. Right? I don't want to use because it's people are becoming. Right? I don't want to use a different language. Right? What does I say? Huh? Pardoning power. The argument advanced to us. He killed somebody in the open daylight in front of an industry. 4 of them went and massacred him. Butchered him. A sitting MLA. And then the argument is a wonderful Congress outcome. Wonderful Congress outcome. And therefore you have to pardon. If the government does not pardon, government's office will go. Right now you see the imbalance. The Constitution is filled with proper separation of powers, checks and balances. Right? We are not, that is why when we are not related, the imaginary, and if you read the Justice Ayer's judgment in Samshasi, right? You are not able to face the second students in the class, 80 students. One of our professors was really well read in the center. The text says this, how can you say in this paragraph like this? How can you write like this? I was trying to defend it. Finally, one student asked, if you say the president is a 0, why did you contest the election? Then it opened his mind. He said, without proper preparation, I will not come to the class. That was his last class. After that, he didn't come. Every year, he used to come and teach. So, unless and otherwise you question, encourage students to question, we also learn. We have learned all these things. We could have also gone through some gate project. Now there is a very popular writer, right? If nothing is there, some teacher has set aside and sitting some next minimum activities. Right? We are defeating ourselves. Right? So this judgment has thoroughly changed, and they use the term power and function simultaneously. That's the problem. Right? And the judges said, now I'll ask another question based on this. I will go back, maybe I'll take another 20 minutes if you have patience to questions. Right? Ordinance making power. All of you would have read the DC Vanguard versus State of New York. Father himself was not a lawyer. Please try to understand, he was not a lawyer. He was a professor of political science at the University of New York. He collected all the information and got to the notice of the court that even without knowing the governor, the ordinances were continued, re-promulgated. For 14 times they re-promulgated the same ordinance. And the same Supreme Court woke up, the 5-judge bench, constitutional bench, woke up and said, it is a fraud on the constitution. 10 years ago you said, the governor has to act on the advice of the Council of Ministers. When you act on the advice of the Council of Ministers, this is what has happened. And now you say it is a fraud of the constitution. Right? After so many years, in around 2017, they went to the court. Again, they created a larger bench, 7-judge bench. Right? Possibly to overrule this DC Varma. But the Supreme Court said no. Krishna Kumar Singh, as the State of India, they said ordinance making power cannot be used like this. Right? If that is a power, and the language is very clear, and both houses are not in session, and there is an urgency, and they create the urgency like our Karnataka administration, right? If the rain is going to come, all the roads will be built 1 month ago. So that they get damaged, next year also they get the contract. So the governor's office will keep quiet. The law secretary becomes very active. He writes a letter. Read that. I did not get this. This letter is printed in the judgment. If anybody wants this ordinance to be re-promulgated, please tell us. Naked exercise misuse of power by the Bihar government, and it was done ultimately. The government did not know. The secretary signs and they extended the ordinance. And therefore, power is vested with somebody. It has to be exercised 20%. Now I ask this question to you before I get into one or two specific judgments. So drive home the point, right? Who is the executive in India? President. Where is it given? What is the executive power? Huh? What is it? 52 or 53? You are very close to 50.
President will be the executive head of the state.
No. No. Absolutely not. I know the article by heart. I don't trust my memory. I read it for your benefit. 53, not 52. The executive power of the union. The executive power of the union shall be vested. This is the one such place. There are only 3 places where the term vested is used. The American Constitution, Article 1 vests the legislative power in the Congress. Article 2, Section 1 vests the executive power in the President. Article 3, Section 1 vests the judicial power in the Supreme Court. So they use the term vest. Right? And only with reference to President and the Governor, the term vested is used in the Constitution. Apart from Article 297, all the law of the sea, all the resources under the sea, right, will be vested in the union. Right? The state government cannot take property right over those things. So the term vested is used only in 2 places. Right? Shall be vested in the President. Now, this judgment of 1973, what is vested in Article 53? The Supreme Court, 7 judges, divested the power to whom? To the Prime Minister, according to the Council. Right? Now, the problem is, we don't read it. If you read Article 53, is the executive power holder, right? They always read Article 74. That is the area of ignorance. The sphere of ignorance is 74 and 75. Right? 74, it says, I hope all of you have read this. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President who shall, in the exercise of his functions, act in accordance with such advice. Is it in conflict with Article 53? 53 uses the term power to pardon. It is with the President. And if you say with the Council of Ministers, you have seen me to Suga's case. That is one case which went to the court. There are many number of cases which have not gone to the court, pardon has been given. Right? So it says Council of Ministers, not even the government. The executive power today is defined as the government power. And there is another judgment which my classmate and the former Chief Justice of India, who became the governor of Kerala, right? Sarasivan, he rendered a judgment before leaving the office. That MP vaccine, MLA vaccine is constitutionally valid. Who exercises the executive power? It is the elected member who is exercising the executive power. And Montesquieu was absolutely right even after so many centuries. The moment you allow the executive power holder to combine with legislative power holder, there begins the end of liberty. There begins the end of liberty. You cannot ride with two horses. And that is why they are not interested in making a law. It's a problem with our system. Opposition has to oppose everything. Right? It depends upon the numerical strength. They don't work as the art of representation given to us beautifully by George Stuart. I hope you must have come across. Please read this book on liberty and representation, representative government. The elected representative acts not only for those people who voted for him, he also acts for those people who have voted against him and those who have not cast their vote at all. That is not a Here they are all interested in doing something except making the law legal. And Sadashiv got a prized position for whatever he has written. Right? Shameless fellows. And there are many such people who are waiting. And then many other people have joined. So therefore, here it says, Council of Ministers, not the government, only the functions, not the powers. Article 72 is not a function. Article 123 is not a function. Article 356 is not a function. And how to identify this power? And that is why you use jurisprudence to understand affiliate analysis, right? What is right, liberty? You have to understand all these permutations and combinations. When I act under dictation, right? It is called as function. When I have the ability to choose between two or more options, I exercise my power. I am not dictated. When the Council of Ministers dictates that you have to do this, right? It is not a power. It is only a function. And that is what they use in Article 74, and then Article 75, so many things. And finally, the Supreme Court woke up in 2005. Justice Inday Santosh Hegde was a senior judge. He had to pen a wonderful judgment. Please read this. Two ministers of the Madhya Pradesh, cabinet or council of ministers, or honorable members of the legislature, whatever language you call, they were involved in some landscape. There is some Lokayuta which investigated, the retired Chief Justice is the Lokayuta there. investigated and said these two people, ministers, were involved in landscape, and therefore must be prosecuted and punished under the PC Act. What is PC Act? Because this is article probably should tell us this though. You know, so that here, one young lawyer came and asked for adjournment. He said, you are a lawyer, any lawyer, and you have studied as a 4-year law course for 6 years. I'll give you 1 hour time, go read and come and appear. Whether your senior comes or not, you come back and argue with us. So he gave 1 hour and said, this fellow came and narrated the facts, the PC Act and the section so PC Act. We stopped him and to the council, repeatedly saying, what is this PC Act? He was nervous, he said, protection of the character. That's what he was doing. That's what he was doing, just dismissed. Right? So under the Prevention of Corruption Act, we must be prosecuted, for which we have a British legacy lingering on. We need the sanction from the appropriate authority. When you ask for the sanction, it never comes to the level of office. Either one of them must be in office. Right? He may retire or the authority must retire. Nothing will happen. Because they all act according to what the ministers say. If one civil servant says something against, he will be transferred from one ministry to a corporation. Finished. Right? This authority also. So they also join the league. Right? Today we have not independent civil service. It is all corrupt, civil service. And therefore they are not able to get it. And sanction has to be given. Somebody advised in the law department that you must take the opinion from the council. So the governor wrote a letter to the chief minister. 2 ministers are involved in this. I have to give approval for sanction, approval for prosecution. Can I proceed? He came to reply, no, you have to act according to the advice of the council of ministers. The council of ministers says you cannot give the sanction. But the governor was strong enough, he went on to give the sanction. Immediately they went to the court, they got out of the nation. The High Court cited this controversy. They got the lawyer also argued, right? The advocate general, 7 judgments, very important. Article 141, you cannot violate. So the judges also said, yes, you cannot act independently. For everything, you have to act only at the circumstance. He went on appeal to this Supreme Court. The state also took an appeal. Both were condemned together. High judgments. One word. There are few exceptions. That's what we see about. And they gave only 2 exceptions. We would like to add the 3rd exception. And the governor was absolutely right in giving sanction, and they need to prosecute that further. So they were looking for exceptions. We have forgotten the rule. We are now looking for the exceptions because the 7 judgments we cannot go. Why you can't constitute a 9 judgments? Overrule. Right? Except that score of 1993 consultation becoming concurrence. And then it went on a general reference under 143 in 2000. They said not 2 judges, 4 judges. The constitution such as the judges, 4 judges. If you have got one more time, they will have 6 judges. Right? Is there any substantial change? And once law acted, we will say our guards applies equally to the law. Once they started enjoying the fruits, right? And that is why the protocols all over, right? Gone are the days when 4 judges used to travel by a theatre, permanent car. They go each and every house, collect them, and go to the court, come back. Now we have an independent car, a gunman, secretariat, right? So they are all flourishing in their life. So power has corrupted them, and they fail to see, fail to read the text of the Constitution. To get them out, what is the requirement? Right? That nobody has written about Bhim Singh's case. Nobody has written about Samshir Singh. Nobody is writing about the judgment even today. Last 3 months ago, the election commissioner was appointed. Right? Um, Somebody went to the Supreme Court, challenged, and then the Supreme Court, some 397 judgment. Right? Whether they sit and write, I don't know. Right? 387 judgment saying that here afterwards, for the appointment of Chief Election Commissioner and Election Commissioners, there must be a committee consisting of the Prime Minister, leader of opposition, if the leader is not there, leader of the largest party, because the presidential situation is that, and then the Chief Justice of India. The judges are also appointed like that. They all go and sit before the law ministers for promotion, for leave, for visits. Justice, sorry, Bharat, who was a governor here, was also the law minister. Very nice man. I have enjoyed lots of fruits with him. Fruits in the sense not getting material. Very, very warm in his relations. With the teacher, not only me, when we see any other teacher. He will hold your hand, he will not leave. Right? And he used to say, Vijayakumar, when I was the law minister, there used to be a bench outside, not even chairs, bench. The judges come and sit there and make him wait. Because they come there to seek permission to go abroad. And some money to come. And make them wait. See the pressure that the minister has. And we also demeaning the positions. We also make others to take pressure out of that. These are all things which are spoiling the atmosphere because we have this in the Constitution, the Constitutional Conventions of the American Constitution, that is England. And interestingly, Article 105 and 194 carried some of the glimpses. The conventions of House of Lords. They mentioned that, so that's why I said, India has got freedom, still we have the clutches, right? In the language and in the articles that we read. And till 1978, 44th Amendment removed that reference and said as practiced by the houses prior to this amendment. Right? We don't have any sense of shame. So therefore, Constitutional Convention is one such important theme which has been neglected by the students and the teachers and the researchers alike. Right? And therefore, I think this as my topic of research. And that was the time I got the judgment delivered by the Supreme Court in 1993 for a judgment. I mentioned it and the comment also is very clearly. On one side, they said conventions are very, very important. And they created a convention as against the written provision for the Constitution, which they do not fully get up. Right? And Jeffrey Marshall, I refer to, I would like to just quote what does it mean. Right? He says, there are other constitutional relationships between governmental persons or institutions besides the conventional rules that govern the powers of the crown. Powers of the crown in India, not in India. Right? Such constitutional relationships illustrate the existence of rules of a conventional character, not written down rules but conventional character. The following comprehensive examples are given by Jeffrey Marshall as illustrative of emerging conventions in the United Kingdom. That also applies to any other constitution, which has a written constitution as well. Relationship between the cabinet and the prime minister. Cabinet and the prime minister. Lal Bahadur Shastri, when an accident took place in Tamil Nadu, right? There is some 100 people died in an accident. He owned the moral responsibility and resigned as the minister of Railways. I hope you remember this. He was not looking for the position as a union minister, but he showed a very high, dignified role of a member of parliament. He continued to be a member of parliament, but he resigned as a minister. When Lalu Yadav was the right minister, there were accidents taking place. Some press fellow went and asked this question. Lal Bahadur Shastri did this. And Rick has a reply, if that is the case, every day you have to appoint a new regular minister. See the attitude, right? And when you have buffoons like this in play, what you get is nothing but surface, right? So between the cabinet and the prime minister's job is to choose the right people, right? I just want to give you this example. The first cabinet, 1947 to 1952, from independence to republic. The cabinet contained 14 members. Out of 14 members, 5 of them were not even Congress members. 5 of them were not even Congress party members. Ambedkar is one. Some Shanmugam Chetty from Tamil Nadu, wonderfully drawing in finance. Anything in finance, he was there. Right? They knew everything. And that is why they are there, the ministers. Right? Then you advise the president as to what is right. You can understand. Today, in Maharashtra, after the election, one Goon became an MLA. And also contested based on a party. The leadership wanted to dilute because if you ask the chief ministership, it will reflect badly on the party and the community. So they negotiated. And he was also nice, he also knew his limitations. They thought he will ask for home ministry. Right? So that not chief minister, any ministry one. First choice was home minister. Because all the cases, the police are trying to find him. He is already contesting the election, won the election, they are still finding him. Right? Now, if he becomes a home minister, the police will give him protection, not arrest him. So they thought he will ask for home ministry. He didn't ask. They were surprised. Then he possibly wants to make money in finance. He said, no, I don't want finance. He was very happy. And he said, I want higher education. 8th standard fellow, a group. Right? Karnataka is not an exception. Mother is not some education minister from Mysore. Right? Very good. But higher education, not even primary education, higher education. Why? His expectation within 2 years, 8 universities gave him honors class, PhD. Doctors also. Right? Venkataraman was the president. After his retirement, he wrote a book on presidential years. He cites an example, 2 examples. Minister for Law and Justice. A minister who had no qualification in law. Now, I think we have been using for more than 40 years. Notwithstanding anything said in the foregoing provisions or some provisions, some constitutions, there we are talking what we are talking in use. And this fellow, he doesn't know what is notwithstanding. He knows what is standing. Right? He becomes a law minister, what will he do? Right? Except signing the dotted line. And another shipping minister, shipping and surface transport, after taking the oath as a cabinet minister, he visits Bombay at the expense of the government of India to see the ship for the first time in his life. This is what Vijayakumar has written in his book. So, cabinet and prime minister today, it is how many MLAs you have. If I give you, I will keep your MLAs in that, I will keep you in that. 5 years successfully, I will do that. That's what we are doing. So it is a harmonious relationship between the Prime Minister and the Council of Ministers. How many of them will be like Lal Bahadur Shastri government? All of them will be like right? Exceptions. The relationship between the government as a whole and the Parliament. Parliament is not the government. Council of Ministers is not the government. The government and the Parliament. Parliament is meant for making the law. Government is there to run the administration. And we have gone down the BMC's judgment I told you, the office of governor given to somebody, right? Delegating everything. Third one, relations between the houses of parliament, Rajya Sabha and Lok Sabha. The relationship between the parliament. Relations between the ministers and the civil service. They don't have a constitution, but they still speak about it. Here we have a constitution, we have a guarantee in 379, 310, civil servants, independence, everything we speak with them. Right? It is killed the moment they are appointed as civil servants. Right? The relations between the ministers and the machinery of justice, the courts. Relations between the United Kingdom and the member countries of the Commonwealth that will not apply to us because we are also part of the Commonwealth. To all these things, you have to conventions developed. I can go on and on, and I will not do that. Secretary Commission referred to these constitutional conventions that we are not doing some good things so that we can elect, some reasonably good people as governors. Right? I don't know why retired politicians or lost politicians must be given this office. They can be taken from Army, Navy, and Air Force. They can be taken from also academics and vice chancellors. Right? Some senior citizens, not all of them, independents, right? In Madras, when Delhi Robinson was there, one among the highest position is chief engineer, PWD. There was only one post of those days. Now Karnataka has more than 50 chief engineers. Right? They have an associate also. Right? And that man was the general director. He used to travel from Barampur to Eliladu by group number 29. These are all stories we use. He will come, he will take the bus, if there is a seat, he will sit. There are many people, subordinates working in the same office. They will, when not seeing a chief engineer standing there, give the seat, he will not take the seat. He will stand and come. If at all officially he will go somewhere else, take the car, otherwise he will not take it. When his term was coming to an end, people are very happy because he cannot be corrupted. And they thought the government also will be very happy. When the backup party was being organized, a letter came from the chief minister extending his services to 2 years. All others who have to retire in 2 years, they curse him like anything. See, there is always some politician who recognize and reform. Right now, always used to be so, but when you have shortcut methods are there. Separation of powers is one such written code. And I have written these, there is the Karnataka State Language in General. This is the Desai Memorial Lecture, Government Lecture. Please, if you find that, read that piece. I have put lots of efforts in collecting information, putting it forward. And today it has become a passion for the Supreme Court to say that we have separation of powers. Right? But I don't know what the meaning is. Right? They say the separation of powers is the basic structure. 23 years after the amendment of the Constitution, in case of the birth, they said it's a basic structure. That's a basic structure. You have killed the office of the president and the government. Right? You have killed the other institution called the judiciary by appointing the fourth fellow as the Chief Justice for rendering a wonderful judgment to protect the fundamental rights. Even during emergency, you have allowed another person to overtake HR command. So you are destroying, and now that work is taken over by the court itself. Right? That is like the separation of powers, checks and balances. And if you don't understand the difference between powers and functions, this is what. Right? I would like to entertain few questions, but before that, I would like to ask 2 questions. Right? Who is the head of the state in this country? It's a very 8th standard question. I'm sorry I'm asking this question. Because 8th standard question, students are taught in a particular manner. They have to give the answer in a particular manner. If they write something else, right? So who is the head of the state?
According to the Constitution,
No, Constitution.
President.
President. Are you sure? Are you sure? Are you sure? 3 times. Okay. The next question is very simple. Very simple. basically power of the union is vested in the president. He doesn't say it's head of the state. He is also chief of army, navy, defense forces. That's also there. He doesn't make him head of the state. Because that function he has to perform only based on a law passed by the parliament. Because they are seeing what's happening in Pakistan and other places. The army generals will become the presidents. Right? So they are very careful. That's fine. What is it given? See, we are not able to respond to this exam question. I can give you a clue. There is something in preamble. Democratic republic is an indication that the head of the state is an ultimate authority. Whatever be the method of election, they cannot remove him from office except the process of impeachment. But making a law, they cannot do it. Right? So the only source I can see is democratic republic to indicate that the president is the head of the state. Okay. Second question. Again, you may have some questions. Who is the head of the government? Huh? Prime Minister, are you sure? Are you sure? Okay. If you are sure that Prime Minister is another state, place in here. Article 74 says there shall be a Prime Minister who is head of the Council of Ministers. Council of not in cabinet, Council of Ministers. It doesn't say government. But what will you do? Go to the Supreme Court. Easy. Right? There is a mini dictionary in the Constitution. Right? There are many dictionaries in the Constitution. One major dictionary among the many dictionaries is Article 366. Right? There are 31 words are being defined. So legally you have to go through that. Unfortunately, you will not find a mention about government. Government is not defined. What do you do? No? There is next article below 367. Will you please read next? And that's why I'm impressing upon so that at least in the classroom, if you make over 60 students, 30 students may learn something. Right? Can you read 367 first part of it?
Unless the context otherwise requires.
It's a language is very clear. If I am a law minister, I cannot understand because I don't have a law. Unless the context otherwise requires. Right? Yeah.
The General Clause Act 1897 shall subject to any evaluation and modification that may be made under Article 378 apply for the interpretation of this Constitution.
Interpretation of this Constitution.
As it applies for the interpretation of an act of the legislature of the dominion.
So these are all right. That's why I said there will not freedom because the abolition of the Independence Act. These are all still like lectures. This act was passed by the British Parliament. Right? And now they say this act will determine unless the context otherwise requires. If it is possible for them to do it, it's fine. Otherwise, if nothing is there, you have to rely upon the General Clauses Act. So please go through the General Clauses Act. Right? Section 3, if I remember right, it's not 2. Section 3, subsection 8. I think you can also open and see. General Clauses Act 1897. Section 3, definition clause. Right? Subsection 8. In that third paragraph or somewhere, after the commencement of the Constitution, the government means the president. Is it there? Section 3, subsection 8. Central government or is it there?
Central government shall.
Is it 8?
8. There are 8 further.
Down.
In relation to anything done before the commencement of the Constitution.
No, after. There is one more.
In relation to anything done or to be done after the commencement of the Constitution, means the president.
Means the president. Right? Now the Supreme Court today says either the government is Prime Minister. They have created a convention because some share seat is there. Is that convention valid as against the written provisions of the Constitution? It's a question. Who will build the cat? So I will leave you with this question. Right? Who will build the cat? Right? If you are going to who else will? Right? Now, if you have some specific questions, I got too many things to say. This 2 hours is very, very limited. 2 hours your interest. Right? I can also be Buddhist, I can say something here and there, or the Supreme Court has said about conventions. Right? In Tamil, there is a saying, in the same thing applies in Kannada also. Overnight you read Ramayana, next day morning you ask for this. Right? The Supreme Court spent considerable paragraphs in Sora as the judgment in 1950 and did sorry against the constitutional provisions. Right? And who will build these judges of the Supreme Court? I'm not calling them cats. Right? Who will build the Supreme Court judges? Right? So now we understand the significance of reading the text of the Constitution wherever it is required. Right? In law school, all 80 students they have to have a text. That is an essential tool. Right? And let me tell you the way that we read, the students read, comma, full stop, break, and R, semicolon. Right? And looking at the judgment and very clearly coming to the conclusion that it is wrong. If that training is not given, Krishna here has no saying for 2 hours in the class. Right? And he did not. Right? And we wanted to go to Whitefield. And we used to go to Whitefield. And there was a student, he wanted me to accompany. I said, I will come with you, sir, but I will not come inside. I will see the blessings. He said, why? I don't have to believe. It is as simple as that. Then can you send somebody? So there was a student, second student, Ramasamy, I still remember. So I sent him along with me. On the way they were discussing and he raised a question. Sir, why do you write a judgment? It's such a language. We need 5 dictionaries to understand what you are reading. Right? Immediately asked the driver to stop the car, asking me around. And he went almost 5 meters away, stopped there and asked me to come. So these are all the things, it's nice to read. We are not talking about Thames or the Potomac River. It is a river in India. Who wants all these things? Whether the government can remove a judge or not, that's also a simple question. Right? Go around, forget the substance and say everything that you want. Sometimes it may be very good. Minerva Mills case. Acquisition of Minerva Mills by the government. They declared Article 368 unconstitutional. So we appreciate it. Right? Let's say, therefore, you have to understand the context in which the period in which given the law is made, how the law is being made, how the judges look at it, The ignorance of 99.9% of the population in this country is the area for blame for the course in this country. Right? To sign off, I'm also a student of political science and public administration. Administration of justice is an essential function of the state. With 4 million cases, 4 crore cases pending in the courts, whether it is an essential function or not, it's a doubt. Right? Thank you very much for the